Good morning, evening, or afternoon to all of you out there in YouTube land watching this video. I am Ellen Klein with Rilso Japan Branch Office Guam, and today's training is on pretrial case screening from the Legalman PDS for Trial Legalman, pages 8 and 9.
Good afternoon, sir. Thank you for taking the time to do this interview with us. So if you could just give us a little bit of a background after you give us an introduction into your trial experience, please.
Okay, my name's Lieutenant Aubrey Charpentier. I've SJA here in Sasebo. Prior to this, I spent 3 years in Jacksonville at Rilso Southeast, and about half that time I was a trial counsel.
So when you read or review a case file and the record of interview, what are you looking for in particular?
Okay, one good thing is typically I'll have had conversations with the agent prior to this, so I'm going to know that the case is coming and kind of know what charges it looks like there might be. But as I'm reading it, I'm going to be thinking about the elements of the crime. Have we been able to meet the elements of the crime? Based on these interviews, based on this written evidence, based on the things in the ROI.
Okay. So if you had more questions that you wanted to have asked by the investigators to the suspect, how would you go about doing that?
Well, one of the good things is, our agents are very good, and it's very rare that I do need to go back. But, as I'm reading it, I'm also, kind of skeptical. I'm kind of thinking of it also kind of as a defense counsel, trying to think of ways I can poke holes in the case. And so, I may say, all right, I know we interviewed the victim, but, there may be a couple of other questions, or maybe, I read an interview from one witness who mentioned somebody else, and maybe that person wasn't interviewed. And then I'll just go and I'll have a conversation with them and, find out why. And most agents are pretty good about, going and they'll just, do more interviews as necessary.
Okay. Do you have any pointers for legalmen who may be reviewing case files or looking through records of interviews?
Just the same sort of things, just kind of read with a purpose. Be skeptical, think about the elements of the of the crime, think about whether you think those are met, and that's a good way that you can provide assistance, to the JAGs, as you're working with them.
Thank you so much for your time, sir. I really appreciate it.
My pleasure. Thanks.
Okay, so now that we've learned the importance of reviewing a case file and ensuring that all the necessary questions have been answered, we want to go ahead and go into the initial pre-screening of a case. And so the first thing that we're going to want to look at is whether the member is in pretrial confinement. If the member is in pretrial confinement, then we will have to complete a 48-hour and a 72-hour requirements. We'll be going more in depth on that topic in training in just a little bit. Okay, so the next thing that you want to do is look at your TCAP checklist, and we're going to be verifying jurisdiction. And when we verify jurisdiction, you want to ensure that you have the fleet temps printout for the member, that you have the NSIPs printout for the member. You want to look at their active duty service date and look at their EAOS. And so the reason why is because members cannot be held past their EAOS unless it's for court-martial purposes, and there's a special request that you have to do, special paperwork that has to be filled out if the member has to be retained past their EAOS. So you'll want to document that for your attorney and let them know that you're tracking their EAOS should it be coming close. After that, you want to verify pay entitlements of the accused. So you're going to want to go to your PSD office and request an LOPG and an MMPA. And these are forms indicating what their current pay is, if they're married, are they receiving other entitlements. You don't want to get to a point to where there's a frocked service member and you're taking payout for the frocked rank vice what they're getting paid for. So that's very important to get that pay documentation. You also want to ensure all of the allegations are within the statute of limitations. And so if you look in the MCM, it indicates what the statute of limitations are per charges. And then also ensure that correct RILSO is reviewing. So that's what's determined on your TCAP form. And so you want to go through those processes. When discussing jurisdictions, List of personnel who are covered under the code is provided in the discussion portion of Rule for Court Martial, or RCM 202. If the member is part of the reserve component, please review RCM 204. This is going to discuss the requirement of active service by the member of a court martial, and it's helpful to also review JAGMAN's 0126 through 0128. And this is going to provide information on jurisdiction as well. In most cases, if the member is on active duty and the charges fall under the UCMJ or law of war, jurisdiction is going to be implied.
I'm LN1 Rebecca Ducline. I'm stationed at REALSO Japan, Branch Office Diego Garcia, and I'm attached to the USS BHR boat crew, and today I'm going to go over pretrial restraint. Specifically, I'm going to discuss the rules regarding pretrial restraint. I'm going to also tell you about how the accused pretrial restraint can impact pretrial negotiation in the court-martial process. I'm going to give you my different MCM and JAGMAN references, and afterwards I'm going to help you calculate the accused period of pretrial restraint. So the different references that I use is going to be MCM, RCM 304, RCM 305, RCM 707, and JAGMAN Chapter 1, Section 0127. So what is pretrial restraint? Well, pretrial restraint is moral or physical restraint on a person's liberty, and we have 4 different categories of those. The least form of restraint being liberty conditions. And liberty conditions is ordering an accused to refrain from doing specific acts. After that, you have pretrial restriction, which is similar to NJP, so an accused can be ordered to remain in specific limits. During this time, they can still perform regular military duties. And then you have pretrial arrest, which is similar to restriction, where a member is going to be ordered to remain in specific limits, but they may not be able to perform regular military duties, such as supervising personnel, or in the event that they need to carry a weapon, they may not be able to arm up. And then you have confinement, which is the physical restraint of an accused. So this is break time or things of that nature. So who can impose pretrial restraint? Well, for officers, it can only be the commanding officer. It cannot be delegated to anyone. However, for enlisted personnel, the commanding officer or any officer can impose pretrial restraint, and it can also be delegated down to any petty officer or warrant officer. So if a member is put into pretrial restraint, there has to be certain bases that are met. Enlisted personnel, the commanding officer or any officer can impose pretrial restraint, and it can also be delegated down to any petty officer or warrant officer. So if a member is put into pretrial restraint, there has to be certain bases that are met. And those bases are reasonable belief that the crime has been committed and that the accused committed those offenses, and that the degree of restriction imposed is required under the circumstances. So of course, if a member is ordered in confinement, there's other bases that have to be met. So if a member is in confinement, whoever is imposing has to believe that the accused is not going to appear at trial, that the accused isn't going to engage in further misconduct, and lesser form of restraints is just not adequate for that situation. So if a member is ordered in confinement, one thing that you have to remember is that the 120-day clock starts then. So from the day of confinement, you have 120 days to get that member to a court-martial. And if they're in confinement, they have certain rights. Of course, the accused will have their 31 Bravo rights, and they have to be advised that they have the right to a military counsel at no expense to them, and they have the right to a civilian counsel at no expense to the government, and they also have a review process. And the review process starts at 24 hours from confinement. So at 24 hours, whoever is imposing the pretrial restraint has to notify the accused CO that they are in confinement and the offenses of which they're in confinement for. At that point, the CO has a 48-hour letter that he has to write, and this is basically the CO's review of confinement to see if the continuation of confinement is necessary. At that point, 7 days from the date the member was put into confinement, you have a hearing. So what are the different options the IRO has? Well, the IRO can continue confinement, and the accused can request a second IRO review at that point. And during the court-martial, the accused can ask the military judge to review his IRO. And at that point, the military judge can give certain credits if they find that the confinement was unnecessary. Or the IRO can release them from confinement. However, if they are released from confinement, they can still be put on lesser forms of restraint. But if they are released from confinement, they may not be reconfined unless new discovery is brought forth to say that to meet the other basis that we talked about before. So what kind of credits can the military judge give at court-martial? There's two different specific types that I'm going to talk about, and one is Allen credit and one is Suzuki credit. So Allen credit is day for day, and this is when procedural rules are violated. So an additional day for every day the rule was violated. So, and Suzuki credit is the legal pretrial confinement. So if the accused asked the military judge to review his IRO and the judge finds that the confinement was unnecessary or other forms of restraint could have been used for the accused, the judge may order more than a day-for-day credit. And this is where it starts getting a little bit tricky when you're calculating your confinement time. So let's take, for instance, if a member was put in confinement on 6th January and their IRO hearing is 13 January. So the way that you calculate it is 6th January to 13 January. So the way that you calculate it is 6th January to 13 January every day. The day that the IRO hearing, if the member is released from that day, the IRO hearing date is counted. However, for court-martials, if the member remains in confinement the entire period of court-martial, the first day of confinement counts, but the last day, the day of the adjudication, does not count. So if the member was put into pretrial confinement or restraint on 6th January and their IRO hearing is 13 January and the member is released from confinement on 13 January, if you count the days, is 8 days of confinement. So that is 8 days credit that the member would receive. If a member stays in confinement from 6th January into the completion of court-martial or the adjudication, and the court-martial is 30 March, which would be 83 days, because you're counting from 6th January to technically 29 March. So that's 83 days of confinement. So confinement time or confinement credit is only counted towards, well, first is counted towards any kind of confinement that is ordered from the military judge. However, it can also be used towards fines and things like that. So if a member has forfeitures awarded instead of confinement and he has pretrial confinement credit, then per the RCM, it is RCM 305. It's 1 day of credit for 1 day of technically pay. So 1 day of forfeitures. So that's how you would calculate it if there was no confinement awarded at court-martial and it was only forfeitures awarded. But that wraps up my pretrial restraint training. I hope you all have a great day.
Good morning, everyone, and to our folks in Hawaii, good afternoon. My name is Ellen Tuhill, and I am with RealSo Japan, Branch Office Guam. My portion of today's training topic will cover legal hold and its effects on administrative processing and pretrial negotiations. The two references used today are Milper's Main articles 1160-050, specifically page 6, section 12, and Milper's Main article 1910-208. A service member can only be placed on legal hold if he or she is pending court-martial proceedings. This is done via Milper's Main article 1160-050. A member cannot go through administrative processing if on legal hold and EAOS has passed. A member that goes to court-martial cannot agree to a separation in lieu of trial, aka a SILT, or an administrative board waiver if on legal hold. The legal hold will negate all administrative proceedings and separations if the EAOS is passed once the court is concluded. A member that goes through the court-martial process and does not receive a discharge will receive an honorable discharge if on legal hold and EAOS has passed. It is the responsibility of the member's command to draft the paperwork and forward said paperwork to PERS if their sailor has formal charges pressed against them and is facing court-martial proceedings. If there is no punitive discharge, a member is still in the military and their EAOS has not passed, then the legal hold will go from an EAOS legal hold to a PCS legal hold, thereby causing the sailor to either await orders for their next destination or to await further administrative procedures. What does this mean for our sailor in the FactSet, Fireman Strait? Since she has formal charges pressed against her and her EAOS is April of this year, 2017, then her command will need to place her on legal hold until the court-martial has completed. If she is discharged and further punished by the court, then she'll receive whatever discharge and punishment the court awards her. If her EAOS has passed and she does not receive a discharge, and for whatever reason the court-martial has concluded in her favor, aka she is either acquitted or there is insufficient evidence to try her, then she will receive an honorable discharge and be separated from the military that way. But that is only if her EAOS has passed. If her EAOS has not passed and her command wants to proceed with administrative processing, then they may do so at their discretion.
Now that we've reviewed all the aspects prior to the referral of charges, we're going to complete the preferral, the receipt, the referral of charges, and the service of charges to the accused. Good morning, Alan, too.
Morning, Elsie. How can I help you?
How are you doing today?
I'm doing good.
I believe you're the accuser for the Seaman Schmuckatelli case.
Yes, sir.
We're ready to prefer charges. If you could please review the evidence and the charge sheet and just let me know when you're ready for the oath.
Copy, sir. I'll give you a call whenever I'm ready.
All right, thank you.
LT, this is Ellen too. I'm ready to take the oath.
Hello, Alan, too.
Sir?
Thank you for that quick review.
No problem.
Are you ready to take the oath?
Yes, sir.
Can you please raise your right hand? Do you swear or affirm that you are a person subject to the Uniform Code of Military Justice, that you have personal knowledge of or have investigated the matters set forth in the forthcoming charges and specifications, and that the same are true in fact to the best of your knowledge and belief? So help you God.
Yes, I do.
Thank you. Can you please sign the full section?
Yes, sir.
Thank you. And we have now just demonstrated how charges are preferred. Morning, Alan, too.
Good morning, sir. Thank you for your time. We preferred charges on one of your sailors, Seaman Schmuckatelli, on the 7th March. I'm here to deliver the charge sheet. A copy of your charge sheet and evidence. I just need you to sign this receipt that you received them.
All right, let me take a look at this. Okay. All right, here we go.
Thank you, sir. And here's your copy.
Thank you very much.
Have a good one, sir.
You too.
Not anymore.
Morning, Lieutenant.
Sir?
Hi, have I ever seen you here before?
No, sir. I'm actually new here. I'm the new mini jack, and I'm here to talk about Seaman Schmuckatelli, one of your sailors.
All right, have a seat, please.
Thank you, sir. So, Siemens Mercatelli has been charged with Article 107 for making false official statement and Article 132 frauds against the U.S. by his fraudulent PH claims.
I'm so surprised about these matters. Siemens Mercatelli has always been such a stellar sailor. Is this case triable by court-martial?
Yes, sir. Since both articles have maximum punishment, this case can be referred to a court-martial.
Please refresh my mind of exactly the details of this case.
So, Siemens Mercatelli claimed that his wife had Liz living in New York City, while it was rumored that she was actually living in Waynesville, North Carolina with her parents. According to RCM 601, the findings may also be based on hearsay.
Well, Lieutenant, based on these findings, I will refer this case to special court-martial.
Copy, sir. I'll just need you to sign the Block 14 of the charge. Thank you, sir. And now that the convening authorities signed the charge sheet, the accused must be served.
And from Yokosuka, Japan, the accused has been served. You've been served. You've been served.
This is Ellen Klein again. My portion of the training today talks about review of the convening order. So we have two references for this. The first one being RCM Chapter 5, 504 Delta, which states General and Special Courts-Martial. A convening order for a general or special court-martial shall designate the type of court-martial and detail the members and may designate where the court-martial will meet. If the convening authority has been designated by the secretary concerned, the convening order shall so state. And where we're going to find the designation of the convening order by the secretary will be in the JAGMAN. And so our reference for this is JAGMAN 0120 Alpha 2, which basically states that a list of general court-martial authorities designated by the secretary is contained in Appendix A1 Yankee. If we flip to the appendix, which looks like this, if you're convening a general court-martial, you should be listed under that list. And so for my purposes here in Guam at U.S. Naval Forces Marianas, we scroll down and we see Commander, U.S. Naval Forces Marianas. And that's pretty much that. Examples of court-martial convening order will be provided shortly after this video segment. Thank you all and have a great day.
Okay, so on the TCAP page, you're going to go to References and Forms, and then down in OneNote Standard Case File is the standard template that we use, and each command edits things a little bit differently, but you can download the standard case file here. So when you open up the standard case file, this is what it's going to open up on. It's the Microsoft OneNote program, and you'll see in the front there's different tabs up here for different subjects. So case items, referral, trial, post-trial, archive. And then if you look on this side, there's tabs within each of the larger subjects. So here we have a checklist, PMM/PMR, which you could copy your actual document onto there, and you can link it so that it goes from the share. If you click on it, it will go to the specific document in your share drive. And then there's just different tabs based on what you might need. Each command kind of changes their OneNote notebook based on what their personal needs are, and it's also very stylistic, but this is the basic Let's see, TMO page, motions, forums. What's nice about the program is that multiple people can edit it at one time. You don't need to press save because it automatically saves things into the files. So it's easy to use, and when you're working with a large group. If you're working with a lot of trial counsel and legalmen, they can all be working on it at once, and it will tell you who's editing what and that type of thing.
And so does it save it in SharePoint and in your share drive on the computer?
No, it does not save it in SharePoint, but it saves it to wherever the OneNotebook file is on the share drive. So you can save it onto your personal drive, but what people typically do is they'll have it in the trial folder in the trial department's share drive itself, so that everyone has access to it.
Awesome. Thank you so much, ma'am.
You're welcome.